The master class has always declared the wars. The subject class has always fought the battles. The master class has had all to gain and nothing to lose, while the subject class has had nothing to gain and all to lose, especially their lives. If war is right, let it be declared by the people. You who have your lives to lose, you certainly, above all others, have the right to decide this momentous issue of war or peace. Today, those words alone would probably not land you in prison. But when Eugene Debs made them as part of a speech to picnickers in Canton, Ohio, he found himself convicted under the Espionage Act. Woodrow Wilson had campaigned that he had kept America out of war. But after his re-election, he did an about-face, sending U.S. soldiers into the bloody European trenches of the First World War. When doing so, he told Congress, if there should be disloyalty, it will be dealt with a firm hand of stern repression. By disloyalty, Wilson meant dissent, and that firm hand of stern repression would be the Espionage Act. My name is Chip Gibbons, and this is the Primary Sources podcast. Primary Sources is a limited series podcast presented by Defending Rights and Dissent. The Espionage Act is a constant topic of this podcast. We interviewed Dan Ellsberg on our first episode, who was indicted under the Espionage Act, and we plan to interview other whistleblowers such as Thomas Drake and Jeffrey Sterling, who both were also victims of Espionage Act abuse. The Espionage Act may sound like a law dealing with spies and saboteurs. The word espionage may conjure images of cloak and dagger operations waged by hostile foreign agents, Alfred Hitchcock's classic film Notorious, or perhaps the novels of John le Carre. What it probably wouldn't make you think of is a conscientious public official privy to knowledge about abuses of power who, tired of government deception, works with journalists to tell the U.S. people that they are supposed to be serving the truth the government has kept from them. But today, the Espionage Act is the main weapon in the U.S. government's war against whistleblowers and journalism itself. Today's guest is human rights attorney and Espionage Act expert Carey Shenkman. He will recount for us the ignominious history of the Espionage Act and how for over a century it has been used to control information and repress dissent. The Supreme Court has long since adopted a First Amendment jurisprudence that makes a prosecution of Eugene Debs or another similar war critic improbable. But the lower courts have refused to extend those precedents to whistleblowers, arguing that while a war critic's case involves quote unquote pure speech, the action of a whistleblower is merely quote unquote in the shadow of the First Amendment. By doing so, they've opened the door to the criminalization of news gathering and of journalism itself, allowing the Espionage Act to cast a shadow over the First Amendment.
More breaking news now. Stunning allegations from a whistleblower at the Department of Homeland Security.
A whistleblower complaint involving President Trump.
What are we doing violating the Constitution? I knew that if I remained silent, that I would be complicit in a crime.
The Wilson administration seeks and gets tough new laws suppressing freedom of speech and opinion.
Before President Obama, there's only been 3 instances of the United States charging someone with the Espionage Act.
Carey Shenkman is a human rights attorney in private practice. He works with numerous free speech and civil rights organizations, including Article 19, the Center for Democracy and Technology, CARE New York, and serves on the board of the Calyx Institute, a digital privacy nonprofit in New York City. He is also part of Columbia's Global Freedom of Expression Project. He is co-authoring A Century of Repression, the Espionage Act of 1917, from World War I to the War on Terror. He was formerly part of the legal team that represented Julian Assange in proceedings before the UN Working Group on Arbitrary Detention and testified at Assange's extradition hearing as an expert on the Espionage Act. Carey, thank you so much for being here today.
Thank you so much for having me, Chip.
When we first started doing this podcast, I thought it was really important that we get someone who can give us a deep dive on the Espionage Act, and you were the first person I thought of. So I'm glad we have our first choice today. So I'm going to go into some specifics from the Espionage Act's sort of, notorious history over the last century. But Carey,
summer too. I mean,
yeah,
no doubt.
Yes, it's never ending. But when most people hear espionage, I imagine they think of like clandestine spies stealing government secrets on behalf of foreign powers, what one might call espionage, if you will. How has the Espionage Act been used over the past 100 years? Has it been limited just to espionage, or has it been used for other more nefarious purposes?
Yeah, so the Espionage Act of 1917 is probably one of the most important yet least understood laws that impact freedom of expression in the United States, basically in U.S. history. And you wouldn't think so initially because, as you pointed out, it's called the Espionage Act. So most folks, when you say the Espionage Act, you would assume that it applies to espionage or clandestine spying on behalf of foreign powers, as folks would typically understand espionage to mean. But the big issue with the Espionage Act is it actually includes quite a bit of conduct and criminalizes almost potentially limitless amount of conduct that goes well beyond espionage as it's understood. And that's been the case since the law was passed in 1917 during World War I. Actually, today, the Espionage Act is the predominant law that's used to criminally charge government insiders and also outsiders now who use the press to inform the public about the activities of the US government. So anytime you have whistleblowers, anytime you have insiders who are trying to inform the public or give details about public policy, whether it's about US misdeeds abroad, whether it's about differences in policy, the Espionage Act is one of the go-to laws to prosecute them. And when you take a step back and think about that, it's a little bit strange because you wouldn't think of a government employee that becomes a whistleblower as being engaged in espionage. In fact, it's actually been one of the key pushes for reform of the law recently, in that one of the problems with the Espionage Act is it effectively conflates several categories of people. So you have traditional spies, but then you also have government insiders, whether they be called whistleblowers or leakers or media sources. You have that cohort of individuals. Then you also have members of the public, members of the press, of journalists. You have you and me, folks who are retweeting articles on Twitter. And there's actually, under the text of the law, members of the public are potentially liable. In fact, that's the government's position in its current cases.
I mean, this is probably a very boring aside. When I was in law school, there was a young woman in one of my classes who was an NSA intern, and the professor started telling the class about a story in the Washington Post about some clandestine program, and she raised her hand to tell him that just because it was in the paper doesn't mean it was still no longer classified, and he was violating the law by discussing the Washington Post. I'm sure she went very far in her legal career at the National Security Agency. So let's go back to 1917 for a minute. Why is this law passed, and what are the debates like at the time?
So World War I is widely considered one of the most politically repressive periods in U.S. history. It was an extremely politically vibrant period, but part of that was because there's very vibrant resistance to U.S. participation in World War I. And of course, the U.S. was initially opposed to entering and becoming involved in the war, which was deemed a European, a foreign war, until Wilson changed tune and famously in 1917 had a declaration of U.S. participation. As part of that, though, there was a very strict crackdown on anything that was considered dissent or disagreement with that involvement in the war effort. The Espionage Act was a pivotal piece of that. In fact, actually, the Espionage Act became the principal tool of what President Wilson dubbed his administration's, and this is a direct quote, his, quote, firm hand of stern repression against the opposition to U.S. participation in the war. And Wilson also declared a zero tolerance policy for anyone who, quote, injected the poison of disloyalty into our most critical affairs. He also believed that U.S. citizens who were perceived to be disloyal to the effort, quote, had sacrificed their right to civil liberties. In fact, in trying to push through the Espionage Act in the initial debates in Congress, Wilson's DOJ unsuccessfully tried to include a press censorship provision, which would have allowed the administration to have pre-approval rights over publications. So taking a step back to your question of what those debates entailed, basically, without a doubt, there were provisions of the Espionage Act that did seek to establish penalties for spying on behalf of a foreign enemy in wartime, some penalties against breaking and entering, to obtain secrets, etc. But as part of that, it also included, as part of this climate, severe penalties for criticism of the war. In fact, Title I, Section 3 of the original act criminalized seditious libel, and that was the main means of repressing dissent. So actually, the first 2,000 prosecutions of roughly 2,500 people under the Espionage Act were on account of their political speech in opposition to the war. They weren't about spying.
And what's the relationship between the Espionage Act and the Sedition Act?
So the Sedition Act of 1918 was actually passed as an amendment to the Espionage Act. So it was effectively a twin and extension of that law. The Sedition Act was later repealed, but the core philosophy that led to the Espionage Act and the Sedition Act, even when the Sedition Act was repealed, that still remained part of the law.
And could you give us some sort of insight in what some of these prosecutions looked like? What kinds of people were prosecuted? What did they said? Obviously, do not tell us about all 2,000 of them. Maybe pick your favorite act of World War I repression and share it with us.
Yeah, I mean, there were a number of, and these were highly sensational trials. I mean, when you think of political trials in U.S. history, I mean, some of the lead contenders occurred during World War I. In part because there was such a vibrant left in the U.S. at the time. So, of course, many listeners know of the Wobblies, and there's Big Bill Haywood, who's a leader of the Wobblies, and he and over 100 other leaders of the labor movement were tried in a mass political trial under the Espionage Act, which was effectively a big show trial. The Espionage Act was also used as a pretext to ban from the mails and effectively shut down a publication called The Masses, which was a prominent socialist publication at the time. And it was over effectively a really silly reason. So there were political cartoons that were implicated in that case. And one of them was literally charged under the Espionage Act, a graphic of the Liberty Bell broken into fragments as a symbol of repression of rights during World War I. So that was implicated under the Espionage Act. Perhaps most famously, though, was Eugene Debs, who was presidential candidate at the time, and he was prosecuted for what's considered one of the most famous protest speeches, his Canton, Ohio speech.
Which was given on the day we're recording this by coincidence. That was actually today he gave the Canton speech.
Yep. And actually, in what was one of the earliest examples of covert political surveillance, his speech was transcribed in real time by federal investigators, and there was a debate over whether he should be criminally charged under the Espionage Act for inciting disloyalty under the Espionage Act. It turned out he was prosecuted. His trial effectively became a trial of World War I. He used it as a moment to bring attention to the injustices of World War I, particularly political injustices, but he was nevertheless sentenced to 10 years in prison over that speech until his term was commuted later by President Harding.
And I've written a lot about the Debs prosecution, and by today's standard, much of what Debs said would be quite mild in terms of criticism of a war. There's actually sort of a debate amongst Deb biographers about whether or not, when he gave the speech, he was intentionally trying to avoid Espionage Act prosecution by sort of couching his language, or others think he deliberately went to make a martyr of himself. We're not doing Deb's historiography on this podcast yet, at least. But like the types of remarks he made were, if war be right, let it be declared by the people. It's always been the ruling class that has started the wars, and the servant class who have done the dying. Fairly mild commentaries. And the Espionage Act was also used to keep Victor Berger out of Congress, right? Who was an elected socialist who Congress refused to seat, and they then have a special election, and he's reelected, and then they just don't let the people of Wisconsin have a member of Congress since they keep voting wrongly, all while we are waging a war to make the world safe for democracy. And just as one last Espionage Act aside, I will tell, A. Philip Randolph, the great Black socialist who had been a labor organizer of the Pullman Porters, escapes conviction because the judge does not believe as a Black man he was capable of writing the things he had written.
I'm actually happy that you brought up repression against the Black community as well, because that there was a thread actually running through World War I and World War II that ties into the beginnings of J. Edgar Hoover's career as well, where the Espionage Act was implicated in prosecutions of the Black press. Because Hoover, early in his career, the Espionage Act, and this is something that we actually go into in the book, was how formative this period was politically, including the act. Hoover had authority over prosecutions and deportations of aliens during and post World War I. And part of that was informed by his own racism and his own xenophobia, which led to his accusations that numerous Black publications were communist in his eyes. There is a famous quote of his where he said, Hoover in a memo wrote, quote, "The Negro is seeing red," end quote, which is, I mean, really remarkable when you look at, I mean, I think today there's a lot of acknowledgement of the problems with Hoover. I mean, I think that's beyond the scope, and I know that's something that you're researching quite a bit and writing
an entire book on it. Yes.
Yeah, exactly. And one reason I wanted to tie that in, but I think that's also another thread, because he particularly used the Espionage Act and the Justice Department rather, and Hoover in World War II as a weapon against the Black press specifically, because equating their dissent and battle for civil liberties was seen as seditious.
And if you're interested in this topic, we did an entire podcast series before this one called Still Spying that was exclusively on the FBI and its legacy of racism, its legacy of surveillance, and the fact that they are quite literally still spying on us, as the title would suggest. So, Supreme Court, great bastion of democracy, upholders of liberty, friend of the common man. What role do they play during this time period?
So the Supreme Court's role in these cases, there's quite a lot of ambivalence among the Supreme Court justices. The first big First Amendment cases were actually Espionage Act cases, Schenck and Abrams, and what's known as one of the most famous dissents in U.S. legal history, that of Oliver Wendell Holmes Jr., was written in a Espionage Act case, Abrams. And during this time, there was endorsement by the Supreme Court of these types of prosecutions. There was some very marginal limiting. There's a principle that was introduced during this period called the clear and present danger principle, which became a bedrock of First Amendment jurisprudence, and that it carried on past World War I. But for the most part, the courts were not protective over First Amendment rights. There were, some marginal limitations, and Holmes had an about face because he was put under a lot of personal pressure by his contemporaries who were on various ends of the spectrum politically, but there are many liberals, some folks on the left who pushed him to take a better stance on the Espionage Act. But still, what emerged, the clear and present danger principle, was not particularly protective of the right to dissent. And what emerged past these cases was a intact Espionage Act that would continue to be used in the following decades and through this day to repress political speech and dissent.
As far as I'm aware, the last time the courts deal with the issue of the Espionage Act being used to suppress speech critical of U.S. foreign policy comes up in World War II with a case called Herzl v. United States or Hartzell v. United States, and Hartzell is no Eugene Debs. He's sort of a repulsive anti-Semite, to be quite blunt. And the courts have a very different ruling then, right? One that's more in line with our modern sort of First Amendment jurisprudence?
Yeah, so in Hartzell, there was this idea that you needed some kind of bad faith or specific intent to secure a conviction under the Espionage Act. And in hindsight, that would seem to be a helpful limiting principle, although the extent to which that case has been cited and relied upon in current Espionage Act prosecutions has been limited. Oh, go ahead.
Yeah, we're going to get to that, I think, when we talk about the Morrison case, or sort of the development of this as a weapon against the free press, which is why we're talking about the Espionage Act today. We're talking about it because it's become a cudgel against journalism. And some of the earliest rumblings of this sort of dystopian future of the Espionage Act come in 1942 concerning the Chicago Tribune, and then again in 45 with a publication called Amera Asia, which I believe it's fair to say was aligned with the Communist Party. Could you give our listeners a brief rundown of what happens here and how it is sort of a sign of things to come? Yeah, definitely. And a good point on Hartzell that pointing out the anti-Semitic nature of Hartzell. Actually, that was a running theme of the prosecutions in World War II. There were still these sedition prosecutions. They were in World War I, but there were fewer. And they also led to less of a public and civil liberties outcry because many of the prosecutions involved really unsavory figures. So you had pro-fascists, Nazi sympathizers, anti-Semites. I mean, they're saying some pretty horrible and don't a lot of them come under the Smith Act by this point? And the Smith Act had been introduced too. So there were some prominent Smith Act prosecutions. So between those two, there was actually a debate within the ACLU, another thread, and we get into this in the book, but the modern civil liberties movement in the ACLU was largely born out of the World War I Espionage Act cases, and Roger Baldwin had been personally involved, but that has its ups and downs as well. And you can kind of, looking at the way the ACLU responds to these Espionage Act cases, see kind of the tension in the civil liberties movement. One of those issues happened with World War II, where there's a split on whether to defend these types of people. Another happens during the McCarthy era, where the ACLU is largely absent in the defense of accused. So that whole thread is fairly well known. But taking a step back to talk about the press, this pivot to press cases in the Tribune and Amerasia. So up to about the end of World War II, the Espionage Act was mostly used against dissent. But towards the end of World War II, we start to see the shift where it starts to be used against the revelation of secrets by the press. And there aren't successful cases, but you see these murmurings of its attempted use, the convening of grand juries, investigations. There have been actually some great books written. There's a book that just came out a few years ago on the Tribune case, but basically, high-level summary, the Tribune case concerned secrets that came out of the Battle of Midway, which was one of the biggest naval battles of World War II. And it turned out that the U.S. had broken the Japanese naval code. And you had this one reporter for the Tribune, his name was Stanley Johnston. He was like kind of this typical swashbuckler, scoundrel type journalist. He's really quite a character and a remarkable guy. There's this whole biography written about him. And he was on board this carrier and got chummy with one of the lead officers there. He never really disclosed how he got the information, but there was a lot of speculation from academics that he got it from that officer. But basically, he had learned that the U.S. had broken the Japanese code, and the Tribune published a front page story that basically described the whole Japanese fleet that had been clobbered by the U.S. In that battle, to detailed specifics. So the description of the ships, even the same misspellings that had, occurred in the U.S. naval notes. So
there were a few layers to the pursuit of the Tribune to try to prosecute them for that disclosure. The Navy was upset because they were concerned that this was a security breach. Although there was a larger political undercurrent in that the Tribune was actually one of FDR's main political nemesis. So the Tribune was one of the biggest conservative papers of the time. Robert McCormick, its editor, was a huge enemy of FDR, huge opponent of the New Deal, and FDR was itching for a way to get back at his old nemesis. So running through this, there was actually a split between the DOJ, the Navy, and the president, all with different motivations of whether to pursue this case. Ultimately, a grand jury was convened. The reporter, Johnson, and his editor were questioned by a grand jury, though ultimately there's no decision to bring charges in the Tribune case. So it was seen as a victory for press freedom, but there was really a lot of anxiety at the time over whether a mainstream newspaper was going to get criminally prosecuted for the publication of secrets. So that was the first major secrecy related case. The next case, as you point out, was in 1945. It's called Amerasia. Amerasia was this tiny, specialized foreign affairs journal off of Fifth Avenue in New York City, and it probably had a circulation of about 2,000. Very, very small journal, but actually very, very highly respected and influential. And as you point out, it was very lefty, and some of the folks on it were,
Party members.
Yeah, Philip Jaffe, was a party member. Although he had, his own politics were kind of complicated. There were that's a whole other thread in that, it wasn't exactly like clear where they were politically in terms of those relationships. But in terms of the readership of the journal, it provided pretty high level political analysis of U.S. activities in Asia, and was widely read actually by members of government and diplomats. Its editors often spoke at universities and were considered experts. But taking a step back, basically, after World War II, there was a big question of what was going to happen to China, because there was a civil war happening in China at the end of World War II. There was the nationalists led by Chiang Kai-shek, and then there were the communists led by Mao. And the two were engaged in infighting, but the U.S. officially backed the nationalists. Of course, history shows the nationalists ended up losing. Chiang Kai-shek went to Taiwan, and that's what happened there. What happened, though, at the time, where there was a group of young diplomats working for the State Department. They're known as the China Hands, and unlike the old school diplomats who were traditionally Ivy educated, came from a kind of Europeanist generation of old school diplomacy. This new generation were often born to missionary parents in China, bilingual. They had a better pulse of what was happening on the ground. And several of these diplomats were looking around at the situation in China and looked back at their superiors saying, hey, wait a minute. Like, why are you backing the nationalists? Like, they are a joke. Like, Mao is more dynamic. He has more support in the countryside. The U.S. has to establish some presence or some in with Mao, because like he's going to take over China. Like they called it way before it happened. Of course, Mao, as we know, took over in the late 40s. So their superiors, though, didn't want to hear it. And slowly these China Hands were sidelined and forced out, as unfortunately there were pretty incompetent diplomats that came into power and doubled down on the position. So what they did is they started leaking to the press. They started leaking their reports to the press, and Amerasia was one of those recipients. But what ended up happening is the Office of Strategic Services, which was the predecessor to the CIA, caught wind of a publication in Amerasia that contained secret information, basically from an internal report. And they authorized a warrantless break-in into Amerasia's offices and they found a bunch of secret documents after that break-in, and then began to tap several of the journalists for Amerasia, including the State Department and other government sources. Where that led, and sorry, a bit of a long story, but it's a really,
No,
really
it's a good one. It's a good one.
Yeah, it's a really fascinating history. Because what happened, you ended up having publishers, editors, and insider sources who were being tapped, had their homes broken into, and then were eventually all 6 of them criminally charged as part of this big conspiracy. And it was reported and touted as, oh, this spy ring was just busted, which was absolutely ridiculous. There's some scholars. I mean, if you look back at the history and what's been written about this case, it's a case that's led to a lot of conspiracy theories. I mean, this case is. I mean, there's strong arguments this case literally started McCarthyism. John Service, who is one of the main China hands of defendants in this case, was one of the first targets of McCarthy and was singled out in McCarthy's Wheeling, Virginia speech. So what happened with that case, basically, no big spoilers here, but the case fell apart. In part because of the government misconduct with the break-ins, in part because there was no evidence of actual espionage. The FBI made allegations of espionage, but that was nothing that was ever, proven. Although to this day, McCarthy at the time and some folks to this day still insist the case was a whitewash and some kind of cover-up because it fell apart.
We're going to talk about McCarthy in just 1 minute, but did a grand jury refuse to return an indictment on the espionage count? Is that what happened here, or it just fell apart?
Yeah, so there was a combination of things that happened. So the Amerasia editor, Jaff, he was charged, but not under he was indicted and then pled guilty, but not under the Espionage Act.
The theft of government secrets.
Yes, so he was technically held criminally liable, but it was for a minor charge of, I believe it was possession of stolen property. It was a much downplayed charge. Service was unanimously acquitted by the grand jury, but the case would actually go on to ruin his career. He would get tried before loyalty proceedings. When he would be acquitted, McCarthy would say, "Oh no, you got to try him again," and it just kept happening. His case went to the Supreme Court. Really, really sad what happened to him. And there have been biographies written about him because Service, and something we draw parallels to in our book between Service and Dan Ellsberg, who are both widely considered to be some of the most brilliant officials and thinkers of their generation. But folks really talented folks like this being forced out of government for expressing their beliefs and trying to inform the public. And
you said earlier, sorry for the long story, but we are here for the long stories on primary sources. That is the pleasure of doing this, is getting these long stories. So as you've mentioned, this brings us now to the early Cold War period. We talked about one Red Scare. Now we're on a second Red Scare, one that is frequently called McCarthyism. Though If you listen to the Still Spying podcast, you would know why it should in fact be called Hooverism, not McCarthyism, but I will leave that
really
long.
I'm actually really glad we bring that point up too. Actually, we have a line about that. Yeah.
So I'm going to save everyone that long story and just say there's an episode of Still Spying with Alan Schrecker, the preeminent historian of McCarthyism. You can check out. But at this point, McCarthy gets involved, and there are amendments to the Espionage Act, right?
Yes.
Tell us about them.
Yeah, so in 1950 is teeing off this second Red Scare, and I'm glad you brought up the Hooverism part, because I know I didn't mention him specifically, but J. Edgar Hoover is quite active.
Always the villain. He's always the villain.
He's quite active, and also with the Amerasia case, Hoover played an important role, and and he and Service were going back and forth. He and McCarthy were going back and forth about Service. But on the 1950 amendments to the Act, so there was this suite of very repressive legislation called McCarran Act, which was passed in 1950 and included all sorts of terrible provisions, requiring registration, is fiercely anti-communist. And as part of that, actually, to very surprisingly little fanfare, there were amendments and reorganization of the U.S. Criminal Code. As part of that, the reorganization and some new provisions added to the Espionage Act. And some of the impetus of that was driven by the Justice Department and law enforcement agencies, which had been brewing kind of over the last years, trying to introduce and expand parts of it. What effectively happened with the 1950 amendments was a practical elimination of meaningful intent requirements under the act. So what does that mean? So typically when you have a criminal statute, and for the folks listening, prosecutors have to establish a few things. They can't just say, oh, you killed someone. There might be a lower charge for killing someone, but you have to establish some state of mind that the alleged conduct occurred under. So it's not just that you committed this act, but it's that you had a particular state of mind in doing so. What the 1950 amendments did was effectively eliminate meaningful state of mind requirements for portions of the act. So what that means is that there is one provision, which is probably the broadest, most controversial provision today. It's Section 793E of the Espionage Act, which publishes the unauthorized communication of national defense information. And there is a limited intent requirement if there's what's called intangible information. So if you're telling someone something else, but if an individual is just sharing a document, all that's required is that be done willfully. So if a journalist publishes a document, technically they could be liable under 793E if it could be established that they did so willfully. Well, what's willfully mean? Well, I mean, arguably everything that we do in life is willfully. I mean, arguably that's not really any meaningful intent requirement. And the academic treatment that the Espionage Act has received goes in the depth of this, just basically twisting spines to try to figure out some meaning or limitation among willfully. But you could say that Chip, you and I speaking on this call, we're doing so willfully. I mean, any conduct is done willfully. The Hartzell case that you mentioned before, it talks about specific intent, and there have been some Supreme Court precedents that have been cited to try to add some gloss to that. But the big threat that changed after 1950 is really the threat of the Espionage Act being used against any member of the public, anyone who has unauthorized possession of national defense information, who communicates it. So it's not just government insiders, but it could be a journalist. It could be a member of the public sharing the story of a journalist. It could be, see, there's a case, there's the Bush administration involving.
We're going to get to that one in a little bit. That's on my list of questions. The APAC case, my favorite.
So the 1950 amendments, I mean, the troublesome part is because of the political climate, there really wasn't much opposition to these provisions. In fact, actually, the ACLU, I mean, this is kind of a dark period, but the ACLU actually, their letters supporting it. Truman supported it. I mean, it is really quite bad during this period. There's another provision too, also Section 798, which punished the publication of what's called communications intelligence. At the time, that was pretty uncontroversial because everyone thought, oh, communications intelligence, that's just highly classified, highly sensitive, highly narrow category of information. Of course, we'll let that publication of that be criminalized. The only problem, though, is that was passed before the modern classification system, before the NSA was even established several years later. And it turned out in the following decades, communications intelligence would become this category of information that deeply implicated not only U.S. activities abroad, nuclear activities abroad, and things that impact the livelihood of people, not just in the U.S., but everywhere. But it also impacted Fourth Amendment rights. And we see that today with Snowden bombshell disclosures, which implicated quite a lot of communications intelligence.
And that's one of the charges brought against him, right? Violating 790. Yeah. So
Exactly. Yeah.
So pretty dark times. We've gone through the first Red Scare, the second Red Scare. Let's come up to the year of 1971, when Dan Ellsberg and Anthony Russo become the first whistleblowers indicted under the Espionage Act. How does this come to be? Is this a long time in the making? Is it a sudden rupture? Is it a surprise? Like, what's the background story here? And we talked to Dan previously on this podcast.
Yeah, and I have to say I deeply respect Dan Ellsberg's work. He's someone we've consulted on this project, since years ago, and it's remarkable too how passionate he is about those similarly situated to him, and how these issues continue to be such an important cause. I mean, it's really amazing. You look at other folks who are implicated by the act, and many of them have kind of faded into the shadows. But Ellsberg, I mean, he's really been such a defender of folks today, and it's really inspiring to see.
Fantastic human being, just wonderful, kind man, brilliant, generous with his time, righteous in his causes. Like I cannot say enough kind things about Dan.
And he can be funny too, and actually a decent musician. But yeah, so
we all love Dan on this podcast.
Yeah, so actually, I might add a footnote that there is a case if folks are really interested. So there was actually a aborted prosecution of an army prosecution of a guy, John Nickerson, in the 50s. It's called the prosecution that lost the space race, and that technically actually was a prosecution of a government insider for disclosures to the press, but it had more to do with policy disagreements than we're going to inform the public of these atrocities and human rights violations being committed. But moving to the Pentagon Papers and Dan Ellsberg case, which of course it's a very famous case. I won't dive into all the details of it, but
Dan goes on for an hour. We're grateful.
I can imagine.
You do not need to do an hour as well.
One of the things that I want to stress about it is it's interesting. We were just talking about Amerasia and the Cold War, and it's interesting when you look at the course of U.S. history and policy. One of the things that really led to Vietnam was the debacle that the U.S. found itself in with its East Asia policy, which you can trace back to Amerasia and its response to dissidents at the beginning of the Cold War. And I think what happened with Ellsberg is really consistent with that, where you have insiders who are really trying to make their voices heard, that the U.S. is engaged in a terrible course of action, and nobody's listening to them. And not only that, but they get forced out and then even criminally prosecuted. But what we see in Nixon is probably the most repressive president vis-a-vis the press in nearly half a century. I mean, Woodrow Wilson was quite bad, which a lot of people don't realize, but Nixon was really terrible, and he had his enemies list, of course. And Nixon used the Pentagon Papers to try to go after the New York Times. So there's a famous Supreme Court case where Nixon had his Justice Department try to stop publication by the New York Times, the Post, the Globe, and many other papers. Those newspapers famously fought those what were called prior restraints, took it to the Supreme Court. And there is a big Supreme Court decision that came out allowing the newspapers to publish the Pentagon Papers. So you open up basically any constitutional law, First Amendment casebook, it's going to talk about that Pentagon Papers case. But the problem is that even though that case allowed the publication of the Pentagon Papers, there were opinions by some of the Supreme Court justices that endorsed the use of the Espionage Act to criminally prosecute the press after the fact. So the Supreme Court case said, okay, the Espionage Act can't be used to restrain the press, to stop you, like prevent you from publication, but hey, the door is going to be open after you published, you might be criminally prosecuted. So that wasn't exactly reassuring. And actually, as a result, the reporting on the Pentagon Papers after that decision, I mean, it's considered this fanfare and huge First Amendment victory. The reporting on the Pentagon Papers slowed to it trickled to a near halt after that. So practically, it really wasn't as much of a First Amendment victory. And actually, there's a whole other story, which if you can maybe get Mike Gravel or any of the folks involved in that on your show, that would be
we've had Dan on at this point, and we've had James Goodale, the Times counsel. We have not had Gravel on, at least not at the time of recording this. Although
so and I know James Goodale, he did an amazing job and had some really novel legal theories in that case, and that's saying it's nothing to in the slightest bit to undercut the work that he's done. I mean, there's an incredible victory. Just as a practical matter, after the fact, the door was left open, as we see today, for the Espionage Act to continue to be used as a tool for repression. And a really important case at the time was that of Beacon Press, which was a publishing arm of the Unitarian Universalist Association. And this it's a wild story. Like I said, I don't mean to take too much time on
we like the long stories. We like the long stories.
But in some, basically, Mike Gravel, he read the Pentagon Papers into the Senate record. He was a senator from Alaska, fiercely opposed to the war, and he made the Pentagon Papers public record. And after that, he wanted to find a publisher who would print the Pentagon Papers, because he appreciated that the Times and these newspapers were publishing excerpts and individual stories, but he wanted this to become a public library of information. And if you actually think back, this is actually a pretty early precursor to the WikiLeaks model and what's actually now become a more widespread publication model that the Intercept, ProPublica, and many outlets use, which is to publish databases of primary documents, which can then be used by researchers, lawyers, journalists, human rights advocates, because you have more value in those primary documents. So basically, the Beacon Press, where 20 or 30 publishers said no to publishing the whole Pentagon Papers, Beacon Press said yes. They didn't have the money to do it. They didn't have the support. They were called, when Nixon got wind that they were going to do this, Nixon called them personally. FBI and Army agents visited them. They started to collect subpoenas, their bank records. And keep in mind, this was a religious organization. Their bank records got subpoenaed. So it was not just a First Amendment press issue, but it was a freedom of religion issue. And it led to this big rallying call, actually, that got quite a bit of attention at the time, but it's kind of died down in history. But I think it's a really significant part of the Pentagon Papers episode, because you have what was a smaller independent press that tried to publish the Pentagon Papers, and there was a serious Espionage Act investigation of them.
That's fascinating. So Dan Ellsberg is eventually charges are dismissed because of the Nixon administration's misconduct.
Yeah.
And then in the 80s, there's another journalist, source, whistleblower, whatever you want to call him, indicted, Samuel Morrison. It's considered to be such a bizarre thing to do, to indict a journalist source under the Espionage Act. Clinton pardons them at the urging of Daniel Patrick Moynihan, not radicals. But Morrison, actually appeals his conviction to the Fourth Circuit. It never reaches the Supreme Court, so it's still binding in the Fourth Circuit, where most of these cases are brought in the Eastern District of Virginia, which is a problem we'll discuss later in the series. But one of the things they refuse to do is they refuse to apply the Hartzell precedent, arguing that Hartzell's a case about pure speech, whereas Morrison's case isn't about pure speech. It's just a case that's in the shadow of the First Amendment. Do you think that if they had decided that what Morrison had done was news gathering and was pure speech, we'd be in a different situation today than we are?
Sure. No, and I really appreciate you bringing up Morrison. Morrison's a very important case. And what we see under Reagan is this uptick in secrecy in spending in intelligence agencies, and also threats to the press. The Morrison case wasn't isolated in terms of the way that the press was threatened. And also, I might add as a footnote that the Repressive Computer Crimes Law, the Computer Fraud and Abuse Act, was was passed into law just around the same time as the Morrison case. So you have a lot of really important developments from a press freedom and secrecy perspective happening at this time. But Morrison at first actually didn't get much attention as a First Amendment case. Free speech organizations kind of brushed it off because he wasn't actually he wasn't a very sympathetic defendant. He was actually a hardliner, pretty right wing, who was advocating. He was upset that Reagan wasn't giving more resources to the Navy, and he was, would kind of constantly mutter to himself. Actually, there was in one article there was something written where someone asked why the defense didn't call Morrison to the to the witness stand, and they replied, "Have you ever met Morrison?"
There's one thing the Reagan administration was notorious for. It was their small defense budgets. So yeah. So as you point out, Morrison was convicted. He didn't take he was convicted, and it went up on appeal. But then free press groups actually then got involved because it was clear the stakes had risen. And that opinion is interesting because there are 3 appellate justices, and there were concurring opinions filed that agreed with the outcome, but their reasoning was contingent on the case not being used to infringe freedom of the press. So freedom of the press did come up, and if you read the concurring opinions of Phillips and Wilkinson, they go into this where they address the First Amendment issues, and they predict, well, we don't anticipate this being used to go after the press, go after journalists. And well, history proved them wrong. This is actually a point that came up. I believe it was in Daniel Hale's case. There was a motion to reconsider based on that, or that Morrison wasn't binding because the situation they said wouldn't happen had happened.
Exactly. Yeah. So as you point out, there were a number of assumptions made in that case. The main judge in that case was deeply unsympathetic to the First Amendment interests. I mean, deeply unsympathetic to talking about, the providing information to the press, turning the First Amendment into a warrant of thievery and other bad language from a constitutional perspective.
So yeah, bad ruling there, one that still haunts us. And I would not be optimistic that if it today would go to the Supreme Court, we would have an outcome we would want. But who knows? So during the Bush years, there's more secrecy, more repression, sort of like the Reagan era. And there's this sort of revamping of the Espionage Act investigations and leak investigations. There's an extremely strange case during this period, one that I cannot wrap my head around either politically or legally, which is, you alluded to it earlier, the AIPAC case. Could you give me some clarity of mind about what exactly went down here?
Yeah, so the AIPAC case, and I know we're running a tiny bit low on time, but the AIPAC case concerned the disclosure of some secrets to lobbyists of the American Israeli Public Affairs Committee, AIPAC, which is a very influential lobbying group. And there were also so there are a few different layers to that case. There's the principal in that case was implicated in providing some secrets to Israeli officials and was sentenced separately for that. But the core issue in the AIPAC case was the core issue in the AIPAC case was that you had these lobbyists who were implicated for the receipt of national defense information and also the oral communication of that. And what was significant for that, with that, is that it was the first time that you had individuals who were not the government insiders, but they were outsiders in the role of the general public. You know, they hadn't signed secrecy agreements with the government, but they were being criminally charged under the Espionage Act. And this caused a lot of controversy at the time. Keep in mind, this is around the same time, too, as revelations, actually shortly after revelations of NSA spying on U.S. citizens. This is when, the so-called war on terror was kicking up into full gear. So it was a very scary time in terms of secrecy as well, and a lot of these issues. And the fear was that this would lead to a precedent where you could have individuals like journalists who were criminally charged. And this actually came up in the case. The Judge Ellis, was somewhat dismissive of the First Amendment concerns. He relied quite a bit on Morrison. He relied on the Supreme Court opinions in the Pentagon Papers case, and effectively said that there should be a balancing between national security interests, and Congress has every right to criminalize this conduct if it wanted to. But
the case falls apart when Obama comes into office because the DOJ says that under Obama that the judge's rulings have made it impossible to prove the case or something. Is that correct? Or
yeah, so this is the part that's tough to sum up succinctly. But what was that?
I've read that ruling, and I'm not as smart as you, and I can make no sense of it. So I'm very happy you're
definitely don't say that. You're brilliant. And
I've read several law professors try to make sense of it, and I don't think they've succeeded either. Although
it was one of the first cases I read on these topics outside of law school, and it was like gibberish to me. But in substance,
it is gibberish. The Espionage Act is gibberish. You try to actually read the code itself.
What it boiled down to was this really esoteric legal question about the different intent requirements between, and whether there's a difference in the intent between if you have what's called intangible information. So if we're just communicating and I tell you the substance of a classified report versus if I give you the actual document. And the case talked about there being a heightened intent requirement if it's information, which kind of makes sense. If you're going to impose criminal liability on just talking about something when there's nothing tangible involved, you kind of want there to be some higher bar. So at issue was the meaning of what it means to have a reason to believe the information can be used to the injury of the United States or the benefit of a foreign nation.
Because in the government official cases that we see, they just say, okay, you got the classification briefing, thus for if you had the reason to believe. It's pure nonsense, but that's what the courts do. But in the case of the AIPAC lobbyist, right, they haven't signed a non-disclosure agreement. They haven't taken these wonderful classification briefings. So it is, and this is of real interest to me personally. I should just disclose this because I worked on legislation to sort of change the reason to believe language in the Espionage Act to specific intent, which is why I keep grilling you on all these different developments in intent. Sure. This is my pet theory of how to fix the problem that is the Espionage Act that you're being subjected to at this moment. So, but yeah, no, it's an interesting case. And chilling. Imagine many people are not sympathetic to AIPAC listening to this, but it's a chilling press freedom case. Which, well, the Obama administration dropped that Bush era prosecution. They resurrected or continued on with a number of Bush era espionage prosecutions, including against Thomas Drake, who'll be on this program, Jeffrey Sterling, who's also going to be on this program, and John Kiriakou, who hopefully will be. We'll reach out to him later, as well as bringing their own against Manning and Snowden. We really see for the first time during the Obama administration where it brings all of these Espionage Act cases against whistleblowers, just the hurdles they face. And we're going to talk to a defense attorney from some of these cases on the next episode. But what are some of the ways in which the language of the Espionage Act sort of make it difficult for a defendant charged?
Yeah, definitely. And I'm glad you shifted to Obama, who
Yes.
into office, promising more transparency than he ends
Most
up.
transparent administration in history.
Yeah,
And we got the most Espionage Act prosecutions in history.
Yeah, and the most Espionage Act prosecution for disclosures to the press, more than all presidents combined. So there's really this exponential increase in prosecutions under the Obama administration, and something that his Attorney General Eric Holder would go on to say was a regret of his, and remarkably, actually. Holder now has joined a consortium of different academics and different policy experts in calling for revision of the Espionage Act, and that was just this past year. It was Jeffrey Stone national security book that just came out. I think it's called like the Pentagon Papers 50 years later or something like that. But in terms of the hurdles that defendants face, I mean, they're really quite a number, and a lot of them are a artifact of the discretion that's given to the executive branch to set the terms of the game of Espionage Act prosecutions. And normally, if there's a criminal law, criminal law gets passed by the legislature. I mean, that's kind of U.S. history, U.S. government class 101. You have your Congress passes law, the executive enforces a law, and the judicial branch interprets the laws, and checks branches. But what happens with the Espionage Act is that's just been completely, the table's been completely flipped. I mean, the executive really has complete control over the landscape. Because what's happened under the Espionage Act is you effectively have a criminal law that's based on classification in substance. I mean, the Justice Department disputes that, but that's really what it's about. It's whether, is something classified? Okay, then it's national defense information. So why does that matter? Because classification is set by the executive branch. So the executive branch basically has the ability to say, okay, we're going to mark this document or this information classified, so that if you disclose it to the press, you could be criminally liable. It doesn't matter how inane it is. It doesn't matter if it's covering up evidence of torture or violations of the Geneva Conventions, or murdering civilians in Iraq. It just matters that the executive branch says it's classified. And that matters because there's no defense to that. As a defendant in Espionage Act cases, you're not allowed to say, this was improperly classified. You're not allowed to say this exposed information. In fact, the times that defendants have tried to do that, they get immediately shot down by the judge. Like, they're not even allowed to make that argument.
In the Daniel Hale case, which, I mean, he pled fairly recently, and at the time of recording this is awaiting sentencing, before the defense even made that argument, the prosecution did a motion beforehand telling the judge to tell them they couldn't do that, citing two reasons. One, classification is the sole domain of the executive, and thus forth, a judge cannot challenge it, even though you're not supposed to classify information based on, concealing bad deeds. And second, and this was just my favorite, and I use that, sarcastically part of this, was that even if information is improperly classified, it's not an element of the Espionage Act that it be properly classified. And so if they do classify information illegally, concealing abuse, whatever, and you do give it to the press, you are still guilty under the Espionage Act, same as if you were to give troop movements to Al-Qaeda. It's just mind-boggling. And the judge just goes, yep, okay. Yeah. I mean, people wonder why there's so many plea deals in these cases. Like the rulings that were made in Daniel Hale's case, there was zero way he could present any sort of defense whatsoever. I mean, I went through and read each of them, and it was just like, I don't see how he's supposed to defend himself here, right? I don't understand it.
Yeah, I'm so glad you brought that up. And I mean, I really appreciate your efforts to try to do something on the legislative front to address some of those holes.
Like rolling a boulder up a hill and having it crush you.
They're really quite bad and quite restrictive. I think the lack of a public interest defense is one of the biggest issues. One of my favorite, and I say favorite sarcastically, but favorite lines actually was when President Obama said that Snowden should come back to the U.S. I think his line was to face the music. And you have these people saying Snowden should come and make his case in court. Well, Snowden making his case in court, it's gonna be, did you? Well, he's also charged under 798, but under the Espionage Act would be, did you willfully communicate national defense information? And that's what the elements of the offense come down to. With some variation depending on the specific provisions, whether it's B, C, or E, but at its core, the question in the case isn't, did you expose misconduct? That's completely irrelevant. It's, did you disclose these documents?
And the jury would never be allowed to hear about the misconduct. I would never get on a jury. I suspect you probably would not either. But imagine you're sitting there, they bring in this guy, they say he's on trial for espionage. And you say, okay, did he give information to the Chinese, Al-Qaeda, whoever? Say, no, he gave information to a journalist. The journalist won a Pulitzer Prize. Congress didn't know about this program because the agency had perjured itself. Or some people in Congress knew, but the vast majority didn't. So Congress then passed a law, the USA Freedom Act, which, didn't do very much, but is intended as a reform, and then changed the law. And then the Ninth Circuit, which couldn't have ruled on the case otherwise, says the program is illegal and likely unconstitutional. Are you going to return a guilty verdict under espionage for that? Of course, right? There's a reason why they're barring a jury from hearing this information. We've discussed the plight of the whistleblowers, and many people have long argued that the war against whistleblowers was a backdoor war against journalists. And we've seen a couple of discussions over the decades between the Pentagon Papers of, can we indict Cy Hirsch? Can we indict James Bamford? Some creepy Reagan guy who wanted to indict Newsweek, Time, and the New York Times. Good luck with that. But
Bill Casey, yeah.
Bill Casey, yes. So many villains to remember. But with Julian Assange, Obama said, no, that goes too far, because if you prosecute Assange, you set the stage to prosecute the New York Times, the so-called Times prosecution. We now see a prosecution of a journalist. Julian Assange is currently imprisoned in Belmarsh as the U.S. appeals his extradition denial by UK judge. How dangerous is the Assange prosecution?
Yeah, I think, as you mentioned, I testified in those proceedings, and I'll kind of recount some of the statements that I made there. We've seen an increasing threat, and there's this uptick under Obama of the use of the Espionage Act, not only against the insiders, the whistleblowers, but against journalists and members of the media. And in these cases, increasingly, you had the journalists being surveilled, or even in one case, the case of Stephen Kim and Fox journalist James Rosen. Rosen was named a unindicted co-conspirator and aider and abettor to the offense, which caused a huge outcry among the press, and what ended up being one of Holder's biggest regrets of his tenure. So you have this theory building more and more that the Espionage Act doesn't just apply to the insider disclosing, but that the publisher who's outside has never signed any agreement with the U.S., doesn't have any obligation, apparently doesn't even need to be a U.S. citizen, is accused of criminal conduct for some sort of assistance to that principle. The issue with that is that this is literally the practice of journalism. As long as investigative journalism has been practiced, journalists have sources within government. They ask them for information. That's not controversial at all. In fact, you go to any major news site, basically they all run a system called Secure Drop, which is an anonymous Dropbox that encourages sources to submit digital documents anonymously. And there's even some sites that have guides like how to leak to us. So, this is widespread practice in journalism, and it's one that leads to a lot of public information, public good. revelation of the goings of government, because you're not going to get that transparency from the government. The Freedom of Information Act is completely broken. You have other mechanisms, internal channels. Give me a break. I mean, we've known since Ellsberg times that those just lead, and you'll have Drake on, you'll hear what happens to folks who use internal channels. I always love hearing that when whistleblowers get told, oh, you should have used internal channels, because that's basically just a way to get punished, to get yourself punished. But going back to the Assange case, I mean, I think it's correct when you have so many voices and coalitions, journalist organizations, not just in the US, but worldwide. I mean, UN officials, you have folks on both sides of political expression pointing out that this case is one of the, if not the greatest threats to press freedom of our generation. And the reason for that is you have a prosecution, an indictment for the first time in US history of a publisher under the Espionage Act for the publication of secrets and for being accused of assisting a source in obtaining those secrets. And the problem, and I imagine you'll have other folks that go into this in your segments, but one of the biggest problems with that case is it's indistinguishable from what any serious investigative journalist does. I mean, there's talk that goes into the CFAA type questions, and those are some of those raise complex questions, but they also many of those elements are also indistinguishable from what journalists are doing. And we've seen just in recent weeks there have been limitations by the Supreme Court on the scope of the CFAA that may end up being relevant. But I think taking a step back, you look at that indictment of Assange and you see the conduct described, you see the description of anonymity tools, secure communications, digital drop boxes. That's indistinguishable from what serious investigative journalists are doing every single day. So, the Justice Department has insisted that this is a limited prosecution, that they say Assange is no journalist. And as I think prominent press advocates have pointed out, those are really disingenuous distinctions. You've already, stated correctly that the Espionage Act doesn't have a classification as an element. It doesn't have whether you're a journalist as an element. And also, it'd be unconstitutional for the U.S. to decide. I mean, that concept is ridiculous for the government to decide who is and isn't a journalist anyway. So those characterizations are really disingenuous. It's an extremely dangerous case, and I think one that I'm glad that you're covering.
And we're going to do later in the series a number of segments or episodes, I believe, on WikiLeaks, trying to cover it from different angles, because I think it's important to also remind people as to what they revealed. A lot of the coverage has gotten very much into Assange as an individual, and I know he's been the subject of a lot of propaganda and vilification on purpose, but I do think people have lost sometimes the role of the information he's published in human rights advocacy, in exposing war crimes. I mean, I actually, when I was an intern at the Center for Constitutional Rights, I sat in a room and watched the collateral murder video with one of the soldiers from it. And about his experience as a soldier was against the war and what that video meant to him. And I'm hoping we're going to go into all of that. My final question for you is, where do we go from here, right? What should we be doing about the Espionage Act?
Well, I think what you're doing right now is vital. I think it's important for folks to be aware of this growing threat. And I think the context that I'm really grateful that you're bringing to light, because these modern day cases, when you look at these prosecutions of whistleblowers and now journalists who are implicated in these cases, and and who knows soon members of the general public, you can tie a thread politically to the beginnings of the Espionage Act in World War I. It's really what are these people doing? They're not like David Petraeus, who's publishing secrets for disclosing them for personal gain. Of course, Petraeus shared them with a biographer, lover, highly classified information, probably more classified and sensitive than anything that any modern whistleblower Espionage Act case involving the media is involved. He just got a slap on the wrist and lucrative publishing deals. So there's definitely a double standard. The Espionage Act is used as a weapon against those who are exposing misconduct, who are engaged in the practice of dissent. And you draw a thread, and that's how the Espionage Act was born. I mean, in World War I, it wasn't being used for Espionage Act. It was used against dissent. You go through follow that thread through the Cold War, through the Pentagon Papers. It's really about stifling dissent and stifling public knowledge and information about what the U.S. is up to during wartime. So I think knowing that context is really important, that broader context. I mean, the Justice Department insists in these cases that it's being unbiased and it's politically neutral. But if you open up if you look at any of these cases, you see how political these are. I mean, often, usually, I mean, with all these cases, up to the level of the president. I mean, just about every single one of these cases I've mentioned, like the Beacon, like the Amerasia, all of them involve the president. I mean, they're so high up. So there's no doubt, the level. And we saw that also under the Obama administration. Like Chelsea Manning her sentence was commuted by Obama. I mean, clearly Obama was, involved in some of the decision making.
He said she was guilty while she was awaiting trial.
Absolutely, yeah. Which, I mean, as a footnote too, is a abuse of power, because technically as president, you're commander in chief. So it's like your boss saying you're guilty mid-trial. So I think efforts of reform have been picking up. They're actually current proposals, which of course I don't have to tell you, been close to, regarding amending the Espionage Act. And we'll see which way the political needle moves on that. Some of the times in the past that there have been attempts to reform the act, the issue has been the proposals have been proposals to make the law worse rather than better.
No, yes. People are afraid to even, I know in the advocacy community, people are afraid to even suggest amending the Espionage Act because every other attempt to do so has just been to make it so much worse. They're afraid if you open up the idea of amending the Espionage Act, you're just going to invite terrible things.
There's an interesting place because the Espionage Act, as it's written, it's not really good for anyone. I mean, even like security hardliners, this is something that we talk about in the book, because we've spoken to folks on both ends of the political spectrum. I mean, there's a political consensus that the Espionage Act is a really bad law, but it just, folks have very different reasons for getting to that conclusion. But I think that there's been more movement. I don't think you're ever going to get to a place, at least through, through relying on the system as it's evolved today, where it's going to fix itself. As you mentioned, the Eastern District of Virginia is where many of these cases are brought. That district, it's considered, as quoted by their own chief prosecutor years ago, to be like the national security bullseye or something like that. I mean, it's where all the intelligence agencies are located. I mean, your jury pool, you're effectively getting folks, either they're part of the IC or their relative is. I mean, so you have the judges there are very sympathetic to national security interests, which, I mean, is just part of it. And that's why the cases are brought there. I mean, prosecutors aren't stupid, and they're doing what they see as their jobs, and they're trying to do good at their job, and that's I mean, that makes sense. That they try to make the strongest case, but in the meantime, it's evolving a law being used to repressive ends. So my main twofold really is the public interest defense, an opportunity to have an actual fair trial. But even taking a step back, the Espionage Act, I mean, it's really several laws, different laws, that are Frankenstein together into this mess. I mean, there really needs to be separate legislation dealing with espionage as we believe it. Then there can be a separate law. I personally am of the view that government insiders who reveal to the press should at most face administrative penalties. They shouldn't be criminally prosecuted. But there's debate over that. If there is a law for insiders, there's been talk about having like a misdemeanor offense. I could see something like that happening, being politically viable. It just really depends. And then you need to have a separate legal category for members of the public and the press, because you can't go charging journalists like you're going to charge the insiders.
I have always argued that there is a clear through line between putting Eugene Debs in jail for saying, if war be right, let the people declare it, going after Ellsberg for exposing the fact that the executive branch had systematically lied to both the Congress and the public in order to facilitate a war of aggression in Vietnam, and going after today Julian Assange, someone who has said that if wars can be started based on lies, then peace can be brought by truth. Clearly, there has been, as your book says, a century of repression. Carey Shenkman, thank you so much for joining us. This has been an amazing interview. This has been very informative, and I think people are going to learn a lot from it.
Great. Thank you so much, Chip. And thank you for putting together the series. And again, I want to plug your own research and your book coming up. I'm very excited to read it.
I'm very excited for your book. So we will have to trade books.
Sure. Yeah.
We'll have a book party.